If you are an Indian professional waiting for your green card, if you have been stuck in the employment-based backlog for years watching your priority date barely move or sometimes even go backward, if you have checked the visa bulletin every single month, hoping for some sign of progress, only to feel disappointed or confused, then what I am about to share with you about the March 2026 visa bulletin is something you absolutely need to understand. Because while the numbers may look like just another incremental update on paper, what is really happening behind those dates, what they mean for your timeline, and whether this movement is sustainable or temporary, that is where the real story is. And that is what we are going to break down today in a way that actually makes sense for your situation. So let's start with what actually happened in the March 2026 visa bulletin. For EB1 India, the final action date moved forward to June 1st, 2022, which is a movement of about 2 months compared to the previous month. And the date for filing moved to September 1st, 2022, which also saw a similar pace of progression. Now on the surface, that sounds like good news. It sounds like things are moving. But before you get too excited, let's talk about what that actually means for you depending on your priority date. Because if your priority date is in 2015, 2016, 2017, 2018, 2019, 2020, or even early 2021, you are likely already current or very close to being current. And for you, this update might not change much unless you have been waiting for your I-485 to be processed, or unless you have been stuck in administrative processing. But if your priority date is in late 2021, 2022, or 2023, then this movement is significant because it means you are now closer to being able to file your adjustment of status application, and that is a huge step. But the question is, how sustainable is this movement? Is this going to continue at this pace, or are we going to see retrogression later in the fiscal year? And that is where things get complicated. Now let's talk about EB2 India, because this is where the backlog is truly brutal. The final action date for EB2 India in March 2026 moved to May 1st, 2012, which is a movement of about 1 month, and the date for filing moved to September 1st, 2012. Again, about 1 month of movement, and I know what you are thinking. 1 month of movement after waiting for over a decade. How is that even remotely acceptable? And you are right to be frustrated, because if your priority date is in 2013, 2014, 2015, 2016, 2017, 2018, 2019, 2020, or beyond, you are still looking at many more years of waiting. And the reality is that the EB2 India category is so severely backlogged that even this small movement is considered progress. And the reason for that backlog is a combination of high demand, per-country caps, and limited visa availability. And unless there is comprehensive immigration reform or a significant change in how visas are allocated, this backlog is not going away anytime soon. So let's talk about why these movements happen the way they do, because understanding the mechanics of the visa bulletin is key to understanding what to expect in the future. The U.S. immigration system allocates approximately 140,000 employment-based green cards per year across all categories and all countries. And within that, no single country can receive more than 7% of the total, which means that countries with high demand like India and China are disproportionately affected by these caps. Now, within the 140,000 total, visas are divided into different preference categories: EB1, EB2, EB3, EB4, and EB5. And each category has its own allocation. And if one category does not use all of its visas, those unused visas can spill over into other categories. And this is where things get interesting, because in recent years, EB1 has seen less demand from certain countries, which has allowed unused EB1 visas to spill over into EB2 and EB3, and that spillover has provided some relief to the EB2 and EB3 backlogs, particularly for India and China. But the problem is that spillover is not guaranteed. It depends on demand patterns. And if EB1 demand increases, then there will be fewer visas available to spill over into EB2 and EB3. And that could slow down or even reverse the progress we have seen in recent months. Now let's talk about fiscal year dynamics. Because the visa bulletin does not move at a consistent pace throughout the year. Typically, the beginning of the fiscal year, which starts in October, sees more conservative movement because the Department of State is being cautious about how many visas they release. They do not want to run out of visas before the end of the fiscal year, so they move the dates slowly and carefully. But as the fiscal year progresses, especially in the second and third quarters, if they see that there are unused visas, or if demand is lower than expected, they can move the dates more aggressively. And that is why you sometimes see bigger jumps in movement in the spring and summer months. But then, as the fiscal year comes to a close, if they realize they are running low on visas, they can retrogress the dates, which means they move the dates backward. And that is incredibly frustrating for people who thought they were close to being current, only to see their priority date move out of reach again. And that is a real possibility, especially if demand remains high. So, what does all of this mean for you specifically? Let's break it down by priority date. If your EB1 India priority date is in 2015, 2016, 2017, 2018, 2019, or 2020, you are most likely already current. And if you have not filed your I-485 yet, you should be preparing to do so as soon as the dates allow. And if you have already filed, then you are likely in the processing queue. And the timeline for that can vary widely depending on the service center and the complexity of your case. But generally speaking, you are in the final stretch. If your priority date is in 2021 or early 2022, you are very close to being current, and this March 2026 update is good news for you because you are now within filing range. And you should be gathering your documents, preparing your medical exam, and getting ready to file your I-485 as soon as your priority date becomes current. If your priority date is in late 2022 or 2023, you are still a couple of years away based on current movement, but the good news is that EB1 India has been moving relatively quickly compared to EB2. And if spillover continues and demand remains manageable, you could see your date come up sooner than expected. But again, there are no guarantees. Now for EB2 India, the picture is much more challenging. If your priority date is in 2012 or earlier, you are current or very close to being current, and you should be taking action now. If your priority date is in 2013, 2014, or 2015, you are still looking at several more years of waiting based on current movement. And I know that is incredibly hard to hear, especially if you have already been waiting for over a decade. But the reality is that the EB2 India backlog is so deep that even consistent monthly movement of 1 to 2 months only translates to 1 to 2 years of progress per calendar year. And that means if your priority date is in 2016, 2017, 2018, 2019, or beyond, you are potentially looking at another 5 to 10 years or more. And I know that is not what you want to hear, but it is important to be realistic about the timeline so that you can make informed decisions about your career, your family, and your future. So what are your options if you are stuck in this backlog? One option that many people consider is downgrading from EB2 to EB3, because in some cases, EB3 India has been moving faster than EB2 India due to visa availability and demand patterns. And if you are eligible to downgrade, meaning your job does not require an advanced degree, then that could potentially shorten your wait time. But you need to work with an immigration attorney to understand the process, the risks, and whether it makes sense for your specific situation. Another option is upgrading from EB2 to EB1. If you qualify for EB1 based on extraordinary ability, outstanding professor or researcher, or multinational manager or executive, then moving to EB1 could significantly reduce your wait time. But again, not everyone qualifies, and it requires meeting very specific criteria, so you need to assess your qualifications carefully with the help of an experienced attorney. Another question people often ask is whether they should file their I-485 as soon as the date for filing is open, even if the final action date has not reached their priority date yet, and the answer is yes. If USCIS has announced that they are accepting applications based on the date for filing, and your priority date is current under that chart, then you should absolutely file, because filing your I-485 gives you several benefits, including the ability to apply for an employment authorization document, also known as an EAD, which gives you work flexibility and removes the dependency on your H-1B employer. And it also allows you to apply for advance parole, which lets you travel internationally without needing an H-1B or L-1 visa. And those benefits are huge for people who have been stuck in the same job for years because of green card sponsorship. So even if your final action date is not current yet, if the date for filing is open, you should take advantage of it. Now let's talk about premium processing, because this is something that confuses a lot of people. Premium processing is available for I-140 petitions, which is the immigrant petition filed by your employer, and it guarantees that USCIS will process your I-140 within 15 calendar days. But premium processing is not available for I-485 applications, which is your adjustment of status application. So even if you use premium processing for your I-140, that does not speed up your I-485. However, having an approved I-140 does give you certain benefits, including the ability to extend your H-1B beyond the 6-year limit, the ability to port your priority date if you change employers, and protection against aging out for your children under the Child Status Protection Act. So premium processing can still be valuable, even though it does not directly speed up your green card. Another major concern that people have is retrogression, which is when the visa bulletin moves backward instead of forward. And this can happen if the Department of State realizes that they have issued too many visas too quickly, and they are at risk of running out before the end of the fiscal year. or if demand suddenly spikes due to a large number of filings. And retrogression is particularly painful because it can happen without much warning. And if your priority date was current and then it retrogresses, you might not be able to file your I-485, even though you were expecting to. Or if you already filed and your priority date retrogresses, your case will remain pending, but you will not be able to get your green card until your priority date becomes current again. And that uncertainty is one of the hardest parts of this process, because you are constantly at the mercy of visa availability and policy decisions that are completely out of your control. Now let's talk about the emotional and practical toll of this backlog, because this is not just about numbers and dates. This is about real people and real lives. If you are on an H-1B visa and you are waiting for your green card, you are stuck in a state of limbo. You cannot easily change jobs. You cannot start your own business. You cannot take risks in your career. And if you lose your job, you have a very limited window to find a new employer willing to sponsor you, or you have to leave the country. And that kind of uncertainty is incredibly stressful. And if you have children, the situation is even more difficult, because if your child turns 21 before you get your green card, they age out and they lose their derivative status, which means they can no longer get a green card through your petition, and they have to leave the country or find their own visa status. And that is a heartbreaking situation for families who have been waiting for years and who are now facing the possibility of being separated. And these are the real human consequences of a broken immigration system. And it is why so many people are frustrated and exhausted by this process. So what should you do right now? First, check the March 2026 Visa Bulletin carefully. Understand where your priority date stands in relation to both the final action date and the date for filing. Second, if you are close to being current, start preparing your documents now. Gather your birth certificates, marriage certificates, tax returns, employment letters, medical exam results, and anything else you will need for your I-485 application, because when your priority date becomes current, you want to be ready to file immediately. Third, if you have not already done so, make sure your I-140 is approved, because that is a prerequisite for filing your I-485, and consider using premium processing if it is available, and if it makes sense for your situation. Fourth, talk to an experienced immigration attorney, not just any attorney, but someone who specializes in employment-based immigration and who understands the nuances of priority dates, visa bulletins, and adjustment of status. Because there are a lot of details and a lot of potential pitfalls, and having good legal guidance can make a huge difference. Fifth, stay informed. The visa bulletin changes every month, and you need to be watching it closely, and also pay attention to policy changes, USCIS updates, and any news about immigration reform, because things can change quickly, and you need to be ready to adapt. Finally, take care of yourself and your family. This process is exhausting, it is demoralizing, and it is unfair, and it is okay to feel frustrated and angry about it, but do not let it consume you. Find ways to stay grounded. Focus on the things you can control, and remember that even though the system is broken, you are not alone. There are millions of people going through the same thing, and there are communities, forums, and support networks where you can connect with others who understand what you are going through, and that can make a real difference. This information is for educational purposes only and is not legal advice. Visa bulletin movements can change without notice, and individual circumstances vary widely. You should consult a qualified immigration attorney for case-specific guidance and before making any decisions about your immigration status or your green card application.